Hey, everybody. It's Saturday Night Live with Anjanette Levy. Thanks so much for joining me. Remember to like and subscribe, spread the word about my little channel here. I am closing in on 4,000 subscribers. Woohoo. So I'd like to get to that 4,000 soon if I could. Please let me know that you can hear me. I think the audio is on and working, everybody. But happy Saturday night. It's been a crazy busy week. I wanted to go live last night, but it was a long day at work, a long week at work, really, really busy because not only did we have this marathon, what felt like 8 or 9 hours, but I think it was like a 7-hour hearing, maybe, lunch breaks, bathroom breaks, whatever. It probably wasn't that long, but it was a long day in court on Wednesday with Bryan Kohberger, plus covering the Lori Vallow case. Yikes, in Arizona all week long, following that, plus like doing all the crime fix stuff for Law and Crime. So busy all week long, and just really slammed with that in life and everything. So it was busy, crazy busy. So the Lori Vallow case, please let me know in the comments if you would like me to do something live on that tomorrow. I will try to fit something in if people are interested, but it just seems like on my channel, at least, people might not be super, super interested in that case, but she's representing herself. And let me tell you, there have been some crazy things that have gone on this week in that case, and me watching her, wow, green chili chicken enchiladas, whatever she was talking about, that, cross-examining her brother, cross-examining all these other people. I mean, there's a lot to discuss, and I know a lot of people are covering that case. But obviously I advertised talking about the Kohberger case on here. So that is what we're going to talk about tonight. And there's so much to talk about that I never get to all of it. So we're just going to touch on a couple of things tonight. One being the whole brouhaha over the AT&T timing advance records for Bryan Kohberger's cell phone. We talked about that, I think, last Friday night. I'm sure we did. Talked about that last Friday night during that 2-hour live I did. That was a long live. Good evening, everybody. I'm going to go through some of your comments. So we'll get to that. But also, I thought we should talk about the alibi stuff. That's not really an alibi. Doesn't sound good for Bryan Kohberger. Doesn't sound like Hippler's like real into the alibi stuff. So I thought we should talk about that. And we may have to, the Amazon stuff is like a monster too. His Amazon records. So there's a lot. I mean, because it seemed like Hippler wanted to pack everything into that one day hearing, even though there were 2 days set aside for motion hearings. One being this upcoming Wednesday, which now I'm like, what's going to happen on that day? It's still on the calendar as far as I know. So who knows? But yeah, Harlot Oscara says none of it is sounding very good for Kohberger. Yeah, I would not say that it was not like a very good day in court for Bryan Kohberger the other day. Not a very good day at all. So Cindy Hollenbeck, Cindy, guys, I should bring Cindy on sometime, and she offered to come on. Cindy actually lives in Pullman, and she and I have met in person. I've interviewed Cindy before for Law and Crime. So she and I kind of know each other and everything. So a little bit. And she says, let me put this out here. I always forget I can put your comments on the screen. It's pretty cool. The alibi of stargazing is odd because it was overcast and I live near Wawawi Park. Oh gosh, Cindy, my goodness. I should just send you the link and you should come on. Wawawi Park, Wawawi. Am I saying it right? Because the first time this ever came up with the park, I remembered because of the time difference. I'm typing this up and I'm like, I don't even know how to say that. So I called the park. I waited till they opened and I'm like, can you say the name of your park for me? And I had the lady say it like 3 times and then I said it back to her. I said, okay, thank you. So every time I have to say it, I say it like 3 times before I have to go on the air and say it to make sure I'm saying it right. So yeah. Yeah. So remember, guys, and if you're watching on replay, I forgot to thank all you replay watchers. I love it when I come on and see comments with everybody watching on replay. Thank you so much for watching on replay too. I love that. I really appreciate it. So like, subscribe, all that good stuff. But yeah, the weather that night was overcast. And every time I talk about the whole alibi thing, I do remind people that when I went out to Pullman and, we went knocking on doors, his downstairs neighbor, who was a woman with children, told me that he was often up late at night. He was a night owl. So he was often up late at night driving around. Or maybe not driving around necessarily. I apologize. But he was up at night. She said he would be like vacuuming and stuff. And she has young children. So you've got kids and you're trying to like sleep and you have to go to work in the morning and the kids have to go to school, or kids sleep at night. You're dealing with this. So it's kind of annoying. But yes, it is it would be super annoying if you've got kids, you're trying to sleep, you're in an apartment. You know how paper thin the walls can be in apartment buildings. I'm sure basically living above somebody who's vacuuming late at night, not so great. So let's talk about the alibi stuff. Let's do that real quick. Let's pull up. I've got Bill Thompson, who literally, guys, I'm sorry. He seems like a nice man. Looks like Santa. It's just amazing. That beard is impressive. So let's look at Bill Thompson. And he's talking about the alibi. I might have to back up a second or two. I might have cut poor Bill Thompson off a little bit when he's talking about the alibi. Here we go. Ooh, let's go back to Bill Thompson a little. Here we go. Here's Bill Thompson. So let's talk about the alibi. Essentially, the state's position in all of this is that Bryan Kohberger hasn't met the qualifications to use an alibi defense. Out driving around is not doesn't fit the bill in Idaho. In Idaho, you have to present a place you were, and you have to give a witness, a person who can say, yeah, I saw him or I saw her at that place and at this time when this was happening. So here we go with Bill Thompson.
Thank you, Your Honor. Excuse me. First off, I want just for the record to make a record of the corrections to the typos that I missed in our initial filing. I emailed Your Honor's staff attorney and counsel over the weekend. There were dates that were wrong. Page 1, item number 2 of our motion. It should be July 27th instead of July 22nd on that particular court filing from 2023. We overlooked, and I apologize, the defendant's July 24th, 2022 initial alibi response, which, as the court can see, essentially wasn't a response at all other than we'll come up with an alibi at some point. And then page 2, item number 7, it should be February 29th instead of February 23rd for the date. And I apologize to the court again for those oversights, and they're certainly entirely my fault. This issue has been argued back and forth in court since 2023, as the court can tell from the numerous filings that have gone back and forth up in Latah County that brings us to today. The state filed in accordance with the applicable rule and statute 19-519 and Court Rule 12.1, a discovery request with an alibi demand that requires the defendant to specify the place or places that he claims to have been at the time of the alleged offense, and then identify witnesses who the defendant intends to rely on to establish that alibi. The state's position is that to this date, the defendant has yet to do that. The best that we have is the defendant was out driving around. Well, we knew the defendant was out driving around. We have other evidence that show the defendant was out driving around. His phone was turned off, so we can't trace his exact location at the time of the offenses, but it overlaps and coincides with the time of the murders.
Okay. So Bill Thompson is saying that the phone was turned off, and they've said this in court documents before in motions. So he's saying the phone was turned off. So that to me makes me think they've done the Celebrate on his phone, on Kohberger's phone, and that they can tell that it was physically turned off, not that it, you're out driving around and it goes off the network because you've gone into a hole somewhere and your phone can't reach the tower or what have you. They've said this now in court, and they've said it on the in a motion that the phone was turned off. So here's the thing. Here's what I'm saying about this. Let's say Bryan Kohberger is indeed the guy, that he is indeed factually the person who did this. Why on earth did you take your phone with you and turn it off? It just doesn't seem very, I don't know. Anyway, we'll continue.
The can's been kicked down the road several times on this, and it's nobody's fault. Judge afforded the defendant multiple opportunities to provide a compliant alibi response. That never occurred. The defendant's response from earlier this year doesn't have anything new or different. It talks about partial corroboration of a partial alibi, which frankly the statute doesn't talk about partial anything, nor can we find that in the case law. The defendant acknowledges that their cell phone expert, Mr. Ray, can't account for the time of the homicides itself. Of course, we know that because the defendant's phone was turned off. So the only person who can testify to an alibi, if there is an alibi, is the defendant himself. If he elects to testify, that's fine.
Okay, another point about this, they're saying again the phone was turned off. One thing that will be really interesting, and things I've seen in other cases, is when you're talking about Celebrate, they'll go back and they'll look at how your patterns and your habits, and people are creatures of habit. They just are. And they're going to go back and they're going to look at patterns on that report, and they're going to see, is this something he did a lot? Did he often turn off his cell phone, physically shut it down and turn it off? So that will be something that comes up in this trial. Now, Bill Thompson's saying, Cy Ray can't account for Bryan Kohberger's whereabouts at the time of the homicide. They can't find anything about partial corroboration of an alibi in the case law. It's certainly not in the statute. So he's saying if Bryan Kohberger wants to get up there and testify about where he was, then great, let's do it.
And the state's position is that he's allowed to testify, but under the statute and the rule for alibi notifications, there should be an order from the court prohibiting evidence from any other witnesses as to the defendant's location at the time of these offenses. The defendant retains his right to testify to that if he elects to do that. But nobody else should be asked to testify about specific places where the defendant has been, because we can't respond to that at this point. And to our knowledge, there's nobody else who can say the defendant was at a specific other place.
What about their cell phone expert, who, as I understand it, will testify as to where he was or wasn't?
I don't believe that that's what his expert can say. The best their expert can say is that before the defendant's phone was turned off, the defendant's phone was south and potentially west of Pullman. But that was significant time or a notable time before the homicides themselves occurred here in Moscow. There's nothing in the cell phone data that shows where the defendant was at the time of the homicides.
You don't disagree about the right to put on that evidence?
No, that's fine. I mean, that's an issue, the battle between the cell phone experts on the activity of the defendant's cell phone and what direction it was, but that doesn't apply to the time when the homicides occurred.
You're just looking to ensure that there's no witness who's going to appear who says, oh yeah, he was at my house at 4:06.
Yes, sir. Thank you.
Mr. Kohberger has consistently maintained his innocence and said that he was out driving in the early morning hours of November 13th, 2022.
And he can testify to that.
I'm going to get to that. We provide
I told you it got spicy. I mean, like this judge, I'm telling you, Hippler, in many ways, I just feel like Hippler, he puts both sides on the spot, but man, I would not have loved to have been one of the defense attorneys the other day because he was like taking no guff. But let's back that up for a second, because when this happened the other day, I was like, holy smokes. And so let's back that up about 10 seconds. Oh gosh, of course I backed it up way too much. Here we go. Let's let Ann Taylor speak again, because sometimes Hippler is off mic a little bit, and I kind of wish he would just not speak so softly sometimes. I need him to really get that mic up in his mouth, because sometimes I can't hear him as well. So here we go. Let's do that again. Okay. Let's start with Ann Taylor again. I'm telling you, I call him dry sass for a reason. So here we go.
Yeah, he was at my house at 4:06.
Yes, sir. Thank you.
Mr. Kohberger has consistently maintained his innocence and said that he was out driving in the early morning hours of November 13th, 2022.
And he can testify to that.
I'm going to get to that. We provided.
She's saying she's going to get to that because they're saying he can't testify. He would be a bad witness because of his autism diagnosis. He has level 1 autism, they say, which is what they used to call Asperger's, means he's socially awkward. They've said he uses really big words, stuff like that. Doesn't sound like much of a charmer. So she's going to get to that. But, you know, she says he's consistently maintained his innocence and that he was out driving around that night. So Judge Hippler, dry sass, says he can testify to that. And she says, I'm going to get to that. So we'll pick that up right there.
Mr. Ray as a partial corroboration of Mr. Kohberger's alibi in an abundance of caution. The thing I didn't want was to be here with Mr. Thompson saying they should have told us they had a partial corroboration, now they can't use it. So that's why we disclosed Mr. Ray as early as we possibly could. Mr. Ray took the stand in a motion hearing last May, I believe, and the state chose not to cross-examine him. I disagree that Mr. Judge gave us repeated opportunities to produce more. There was a mix-up about what an order meant when speedy trial was waived and the trial was reset and all of the deadlines were extended. That was the thing that happened there. So it wasn't repeated times that we had an opportunity to say more. But I will say this. This has been brought up repeatedly by Mr. Thompson. His pleadings with the court, his briefing, have a lot of reference to Mr. Kohberger having the ability to testify. In the few minutes he spoke just now, I counted 5 times he made reference to that. Our view is that's getting dangerously close to commenting on his right to remain silent. And I would cite the court, the closest case we could find was State versus Haggard. That's at 94 Idaho 249.
I think the issue is who's going to say he was out driving around looking at the stars?
Well, Your Honor, I think that's going to be a trial issue, and I think that if that's commented on trial, that's a comment on his right to remain silent.
The question is whether they can comment on it. The question is whether you have a witness who's going to testify to that he was at a particular place between the hours of 2:57 and whenever his phone came back on in 5, whatever it was, 4, so whatever it was.
448.
4:48. If so, you have an obligation to produce that. If not, and your testimony, your presentation is that this is what was going on, you have to have somebody that's going to put that into evidence. You can't testify to that.
I'm certainly not planning to testify to that. I'm responding to requests for alibi. And a lot of times in cases, there is not going to be a response because a person's alone. The court's aware of that. But when you have what I considered a partial corroboration.
Okay, so I think Ann Taylor does make a good point there. You know, I get what Bill Thompson is saying. Yeah, he can testify to that if he wants to get up there. And yes, Bryan Kohberger does have a right to remain silent. However, when you raise an alibi defense, when you say, here's my alibi, I'm going with this. This is my alibi. I wasn't there. I was there. I wasn't there. I was here. You are required. That's what the statute says. You have to put, if you're saying you were somewhere else, I was at the specific place, you have to say somebody saw me there, or you have to produce a witness. And that's what the statute there in Idaho says. Ann Taylor, I think, does have a point, though. I mean, he does have a right to remain silent, and he has a right not to testify and not to take the stand. So maybe it is, I'd have to look up this Haggard case she's talking about. But maybe the prosecutor is pushing it a little bit with this. So she's like basically putting the court and the prosecutor on notice, like, hey, I'd watch my step. But then the judge fires back and says, yeah, but if you're going to say he's there, you have to put that into evidence. The only person they're using to put that into evidence at this point is Cy Ray, the cell phone expert. And all he can do is say, this is where he was when the phone went off. And this is where he was, in my opinion, when the phone came back on at 4:48. So we'll watch Ann Taylor again.
That had to be put out there so that I could make sure I could call Mr. Ray to the stand.
I don't think they're contesting that, so as far as I can tell.
That's what I heard them say today as well. I'm explaining why we put that out there. I would say that the state is continually asking a question that is a problem that hasn't arisen at this time yet. The only fear that I have, because of their repeated questions, is that there is something somewhere in the 68 terabytes of discovery that I haven't come across yet. If that's the case, I'd ask the court, if they know of it, I'd ask the court to order them to tell me about that. I can let the court know I haven't read every document in 68 terabytes. I haven't watched every minute of video in 68 terabytes of discovery. We have answered the question now. We've answered the question before, and this continues to come up. I would point out, though, that Idaho Code 19-513, subsection 3, that says if we learn of an additional witness that was not previously known, we can disclose that and the state can challenge that at a later time. I don't have that person now, but if I continue to review discovery that the state produced to me and I find something, then I'll bring it up. but I don't have that now. What I have is partial corroboration, and that's what I intend to produce. I also intend to cross-examine the state's expert about that if he's allowed to testify. That's it.
So just so you know, Ann Taylor is talking about Nick Balance, the FBI cell phone guy. She doesn't want him to testify. She lists a number of reasons why. We're not getting to that tonight. But she feels the disclosures from him have been late. And then we're going to get into that whole cell phone issue here soon. Remember, guys, if you're watching live, thank you so much. Please hit the like and the subscribe button. The like will help my video kind of spread and get recommended and all that good stuff. So please give me a thumbs up and please subscribe. And if you're watching on replay, thank you so much. I love that. I love it when people come and watch on replay. It's very fun. And hi, Tayo Toys. You're a hoot.
Your Honor, the notion of partial corroboration of the alibi is concerning because that kind of begs the question between complying with the alibi disclosure statute or not. And
Well, why shouldn't we just look at this in terms of the defendant's version is that Mr. Ray, in his expert work, is going to testify the defendant was at a certain place at a certain time, which is up to 2:50, whatever it was. As of this point, they have provided no other alibi witness.
Yes, sir.
Or the alibi instruction likely is not going to be given.
Yes, sir.
If they come across evidence that supports an alibi, is their obligation to immediately make you and the court aware of it? And then we'll deal with the issue of whether it is the timeliness of it and how we deal with it.
Thank you, Your Honor. The court articulated it much better than I could. That's exactly what we were looking for. Thank you.
Right.
Okay. So as far as Hippler is concerned, there's no alibi at this point in time. So he's like, there's no alibi. They haven't met the requirement. And so the cell phone guy, Ray, is going to testify. Tayo Toys had kind of a snarky little comment here. Maybe he met Ray, the cell phone guy, in the park. I highly doubt that.
Right, let's talk about
that was good snark.
AT&T stuff.
Okay, we're going to talk about the AT&T stuff, but I'm going to pause this before we do. So, guys, here's the deal. The AT&T stuff caused a big hullabaloo, big hullabaloo. And, excuse me, what happened was Ray, the cell phone expert for the defense, filed this declaration. Ann Taylor had wanted him to testify. She had filed something asking that he be allowed to testify about these timing advance records. Timing advance records are these records that apparently measure the speed of light or something like that. And if I get this wrong, sorry, but they measure how quickly a signal is going from a tower or something like that. I read this like over a week ago, and so I might be mixing up terminology, but allegedly they are very good at determining a cell phone's location, where it is exactly. You can do all these things, according to Ray, to use those to determine a cell phone's location. Those records, according to the prosecution, and you're going to hear a little bit about this, were only retained by AT&T for 7 days in November, December of 2022. They got a bunch of them for some of the victims, apparently, and did tower dumps after the homicides and got those. Bryan Kohberger wasn't identified as a suspect until the December 19th, so they didn't get those timing advance records for him, allegedly, until they couldn't get them for him because the 7 days had, elapsed by the time he was identified as a suspect for the night of the murders. Ray filed this declaration saying, guess what? There's this way that the FBI, it wasn't through this global legal demand center that the state's talking about, but back then there was this other way for the FBI. It was like this backdoor way that the FBI could get these timing advance records. I know because I've seen them do it. Basically, an FBI agent sent me this stuff back in 2021. I have a paper trail. And so I know they can do it. I know they can get these records. There's a backdoor with AT&T. So it almost sounds like the AT&T and the FBI have got some kind of like something going on, which kind of freaks me out if that's really true and that's what's going on. Thank God I don't have AT&T, because I'm like, I don't want Big Brother spying on me, even though I'm like the most boring person on earth. So, my cell phone stuff is people would be like, what? Snooze fest if they started looking at my stuff. But he's basically saying he filed this big declaration saying essentially that he didn't address the 7-day retention period thing that the state says AT&T had back in 2022. The retention period for these timing advance records is now 13 months. But he called out basically the feds and said, it's almost like he's accusing the feds of doing the fibbing here. So it's almost like he's saying he thinks that the FBI has these records and they're just not forking them over because they had this backdoor way of getting them. So things got hot when it came to this. It got spicy. So let's listen to Ashley Jennings, the assistant prosecutor from Latah County. She's going to talk about this, and you'll hear her talk about it. But Cy-Ray, it sounds like she still thinks that it sounds like Cy-Ray thinks there's some backdoor, and that it sounds like the defense thinks the feds have these timing advance records.
Thank you, Judge. This should be fairly simple. The state's seeking an order prohibiting the defense from continuing to allege that the state received timing advance records from AT&T for Mr. Kohberger's
When you say continuing to allege, I'm assuming you mean in front of a jury.
Yes. What we don't want, throughout the entirety of this case, they've alleged that. We're seeking to prohibit them from making that same allegation in front of a jury because it's false. Timing advance records, really timing is what's at issue. And in 2022, the days that we're concerned about are 7 days. The event that we wanted records for was obviously November 13th. So in 2022, we had 7 days from November 13th to get AT&T timing advance records for anyone's phone. We did do search warrants for other people's phones. We did a tower dump, and we did a search warrant for 3 individuals. Those were all done on November 16th within that 7-day period, so the state did receive some timing advance records. However, by the time that Mr. Kohberger was identified in December 19th, and by the time we applied for a search warrant for his AT&T records, we were outside of that 7-day window, so there were no timing advance records to be received, and we did not receive any. The state has submitted an affidavit from Stephen Gordon, the AT&T Director of Compliance, essentially stating that we sought timing advance records, but they were not included because more than 7 days elapsed since November 13th, 2022, and the date of the search warrant, December 23rd, 2022. And the state just submits these affidavits should be dispositive of this issue.
Defense filed a document yesterday, and I don't have all the attachments, but it talks about a timing advance that was produced by AT&T in last April, I think.
Yes, so for that, it's still in reference to these search warrants that were initially asked for in November 16th of 2022. We did a part 1, and then later we did a part 2. But because we put in that request within the first 3 days, obviously a preservation request was also put in. So those records were obtained. So again, we're talking.
You're indicating that there were records obtained as part of your prior notification of need for AT&T to preserve those records.
Right. I have nothing further. Thank you.
Guys, this is where it's going to get hot.
Your Honor, we're requesting the court deny the state's motion and allow us to cross-examine their expert, Nicholas Balance, with regard to timing advance
What
records.
evidence do you have that timing advance records existed that the state could have acquired for Mr. Kohberger?
Well, Your Honor, specific,
I've read your affidavit of Mr. Ray, and he seems to entirely ignore the 7-day issue and doesn't address it.
Your Honor, his affidavit, I think, starts before to explain to the court some of the history about where the timing advance records come from. When Mr. Kohberger was identified, I'm going to jump ahead and tell you why I think I should get to ask Nick Balance about these records. When Mr. Kohberger came to the attention of the state and they began doing search warrants for Mr. Kohberger's records, on December 23rd, there were 2 separate search warrants for Mr. Kohberger's AT&T records, and they requested timing advance records. And one of the pages that we gave you was the carrier request that said, give us 7 days worth of timing advance records. There were 7 days back, at least 7 days back at that time. Those have never been produced to us. What I've learned in working with Mr. Ray is that obtaining timing advance records now goes through a different process than it went before. FBI agents had a means to get these timing advance records before they were generally available to all of law enforcement. Generally available now comes through the GLDC program, and that happened in 2023.
But he's not indicated he has any evidence that, at least for the time of the murder, that those would still be in existence.
We've never heard from Nick Balance, who is FBI and who has the back door.
From AT&T.
You've heard from AT&T that GLDC did not produce these records in 2022. You've absolutely heard that from AT&T. What you haven't heard is the other way that...
The other way. I haven't heard that either. I've heard a general description, and I've heard in the affidavit that he received some once, and they said, oh, no, don't use those. I don't know if those were acquired within the 7 days. He doesn't address the 7 days. And that's a glaring, particularly given the inflammatory language in that accusations in that affidavit, it's a glaring omission.
Your Honor, we don't even have the 7 days worth, which is what the carrier request says. That
The 7 days that he's back home,
maybe.
I'll ask the state about those, if they receive those. I'm not sure their search warrant covered that time frame, but.
Your Honor, I would say that it did, and I would say their first search warrant was just a 48-hour period. It asked for timing advance records, but then the second warrant,
You would agree there's no evidence that AT&T provided those, or that those were still available by the time that Mr. Kohberger was identified?
Your Honor,
An officer of the court.
as an officer of the court, I would like to ask Nick Balance that, and here's why. Here's why. The things that I've learned is that the 7 days is on paper. Sometimes they go back further than other days.
What's the evidence of that, counsel?
The evidence has been in the practice that I've learned from people that I've worked with.
You're giving me that testimony now?
I'm not giving you testimony. I'm answering the court's question.
Okay. But you've made some serious accusations against the state of hiding evidence, and yet you've provided no factual basis, zero, that that evidence existed for them to be able to obtain it in December.
Your Honor, in April of, or I'm sorry, it was probably by the July date that I got it, of 2024, I got records from 2022. In some other time in 2024, I think it was May, I got 3,800 people's timing advance records.
Because they were asked within 7 days of the date that they sought it. It was the tower dump from the night of the murder asked within the 7 days.
I understand that.
Okay. So where is the evidence that Mr. Kohberger's timing advance records from AT&T were available to anybody in December without a prior request that they save those?
Well, I don't know if they made a prior request that they save those.
Well, they wouldn't because they didn't know who he was.
You're correct. They didn't know who he was until, I think, about December 19th.
Correct.
Their warrant for his full scope of records, the second AT&T warrant, asked for all of the records. I haven't seen any of them. That's, even if they were just the 7 days back, I haven't seen any of
What
them.
you're talking about now is a discovery issue of those 7 days that don't sound like they're particularly relevant to the murder. That's a discovery issue you can take up with the court through a motion to compel, which you have not filed. It's not an evidentiary issue in which you can lay down Mr. Ray's conspiracy theory without any evidence at trial.
That whole conspiracy theory thing, when he said that, I was like, oh my gosh. So let's continue to listen.
Your Honor, we have litigated this issue quite extensively throughout the course of the case. The timing advance records, once I understood how timing advance works, became very important. We've heard different things now than I've heard at different times in the past about this, particularly about the 7 days. That's newer information to me now. But the carrier request forms tell me I should at least have that. I want the court to know that we have had motions to compel on this very issue. We have had different bits of information.
For the 7 days that are after December, in December?
No, Your Honor, because the 7 days is something that's newer and has been brought to my attention
Our
more
motion to
recently.
compel related to timing advance records for November 13.
Our discovery requests were for all of Mr. Kohberger's timing advance records. Our motions to compel covered all of them too. I have this carrier request now that says 7 days, and I have the affidavit now that says 7 days. Those are not things that I always knew when we were litigating this issue.
Okay.
Those are new bits of information. To me, it is a little bit problematic that there's been things that have changed and there might be records out there. Given what you have now with the affidavit with 7 days, if you imagine you didn't know that and you...
I understand your confusion and concern previously. What I don't understand it is now. In light of the evidence, I don't understand Mr. Ray's accusations without addressing the 7 days that he had that information when he submitted his affidavit.
He is available to testify if the court wishes for him to.
It's his obligation and your obligation to establish that evidence of that the state has this, and you haven't done that. His affidavit is quite extensive, and he seems to ignore that issue.
Your Honor, I believe that that issue is touched on with his knowledge that these kinds of records existed a long time before.
He said that in a very general way about that without reference to the 7 days, and he supposedly received them from some FBI expert to look at for his company, and then was told not to use them. So I don't know, maybe the FBI got them in a way that they weren't supposed to at that time, for all I know. He didn't name names, he didn't identify it, he didn't put it into any context. The state had indicated and provided AT&T's sworn testimony that they only keep them for 7 days. And yet he makes the accusations that he did in his affidavit without addressing that 7-day issue at all. And so I guess my point is if you want to cross-examine the witnesses about why didn't they rely on the AT&T timing information, you've got to show some factual foundation that that was available to them by the time Mr. Kohberger was on their radar as it relates to November 13. And I'm not seeing that as the problem.
My first question to Special Agent Balance, who would be the person who would have gotten these through a different channel, through the FBI, would have been, did you get them? Because I've heard different things along the case, asking him the question is really what I wanted to be able to do. And that's why I opposed this motion and prepared it as I did.
Tell you what, I'll let you ask that question outside the presence of the jury
Thank you.
at the time of trial.
That will satisfy me. Thank you.
Cat Q says here, now I lost your comment, Cat Q, sorry, that Cyray needed to really, Cyray really needed to address time limits 7 days or otherwise for any method to get timing advanced data. I'm wondering if he just didn't know what time limit, if any, the non-GLDC method has. Well, he should have, because the state put it in one of their responses or something, or replies. So it was in there. So he should have known. And Ann Taylor, he and Ann Taylor should have been discussing that, but it wasn't addressed at all. So it should have been in there and he should have addressed it. Beautiful Messy Ball says, just saying AT may not be that far off base with a conspiracy. I mean, if Nick Balance somehow got these, let's speak hypothetically now, if he somehow got the timing advance records through this backdoor other non-GLDC program, I mean, then he needs to provide that to the state. But he's the one that first told Mowry to tell Ashley Jennings to write that into the search warrant stuff, to the request for timing. He told her, or told Mowry, to get the timing advance records or to request that. So he's the one that initiated it. So he's saying request that. That data would have been delivered, I think, to Mowry, since the warrants were for them. The FBI was in a supporting role then. So we'll see how this all pans out. Remember, guys, if you're watching live here, please like and subscribe. I'm trying to get to 4,000 subscribers. And if you're watching on replay, thanks again for watching. I'm going to skip ahead now. I wanted to share this. Since this happened, let me pop this up on the screen. Since this whole brouhaha happened, Cyray, and I don't know if Cyray did anything, but the actual the lawyers for Bryan Kohberger filed an order, or not an order. The lawyers filed a motion to seal an exhibit. And so they filed an exhibit 4, in support of their AT&T, their objection to the state's motion in limine regarding the AT&T timing advance records. This happened the day after the hearing. So they filed some exhibit, and it's been filed under seal. So is it this whole email exchange Cyray referenced? I don't know. But it's in there. So there's something that's been filed after this hearing took place, some type of exhibit. So who knows what that is. Let's talk really quickly about the Amazon Click stuff. I'm going to try to find that for you really quick. This hearing was so long, and I just did the math. It was Alyssa Masseth. She's the one that took care of this. So, okay, here we go. Yeah, here we go. So this is the Amazon Click stuff. The defense does not want Bryan Kohberger's shared family account Amazon Click data coming in. And we learned some new information about the purchase of the K-bar knife on here. So let's look at this. Oh, I didn't play the part where Hippler said he was mad. He was upset either. I forgot to play that part for you, but let's get to the Amazon stuff. I'm going to speed up this. I'm going to speed this up. Sorry, guys. I need to share my screen. Told you it's been a long week. Apologize. Oh gosh. I started playing something and then didn't reshare my screen. Here we go. So you're sitting here just looking at me.
As Taylor was talking about, we still didn't have those at the time that it was time to file a motion in limine. So our motions in limine. So the motion in limine related to Amazon Click and Amazon Records has to do with a lack of disclosure. When we filed the motion in limine on Amazon Records, we then got supplemental disclosures on Shane Cox and Agent Douglas, but not with any opinions.
Are they expert opinions or witnesses, or are they just fact witnesses to say, you know, here's what the Amazon records show?
Well, I'm going to explain why it falls under expert opinion and what we've come to learn in trying to figure out what this data is. And I'll
There may
talk.
be some rebuttal stuff in there based on your disclosures in terms of why the Amazon data, as I understand it, you're saying shouldn't be relied upon or admissible because AI made me do it.
Well, I think it's a broader explanation.
So Judge Hippler, so basically, Judge Hippler, let's back that up for a second. So Judge Hippler is talking about how they've got this expert guy, the defense, and he's basically saying that he just said their expert is saying AI made me do it, like basically about the putting the K-bar in the cart on Amazon or looking at it again, because the state is saying Kohberger buys this K-bar in March of 2022 and the sheath and the sharpener, but then he goes back after the homicides and looks for another one. And the defense is saying, oh, there can be so much stuff that's featured or that influences what you do on Amazon, there's AI, there's all this data, there's all this stuff. So Hippler just kind of like, dry sass throughout, AI made me do it or whatever. I was like, holy smokes. So let's play that again.
But not with any opinions.
Are they expert opinions or witnesses, or are they just fact witnesses to say, you know, here's what the Amazon records show?
Well, I'm going to explain why it falls under expert opinion and what we've come to learn in trying to figure out what this data is. And I'll
There may
talk.
be some rebuttal stuff in there based on your disclosures in terms of why the Amazon data, as I understand it, you're saying shouldn't be relied upon or admissible because AI made me do it.
Well, I think it's a broader explanation than that. But the issue is that we had received this data and without expert opinions to explain what the state intended to do with it, it left us in a spot of trying to figure that out.
How was it vague what they were trying to do with the Amazon records? It was pretty facially evident what the relevance of those
They're
were.
not facially evident, Judge. We have an Excel file that has a ton of names with metadata, and then we have what is known as an Amazon click packet that the state has produced, we think from Shane Cox, that has a sheet that talks about specific purchases that include the knife, include things like the gift card that you were just talking about, but without any context. And our hope was that with expert disclosures, we would understand, was there going to be testimony from them that somehow there was information on computer searches specifically from computer examination, or the context of what metadata might explain about the ClickPay documents that they got. We now have some information because we have got an Amazon expert who has explained to us what we.
Okay, so the gift card she's talking about, and maybe I skipped over it, but Judge Hippler said that Bryan Kohberger used his credit card to buy an Amazon gift card, and that Amazon gift card was used to purchase the K-bar knife. So that was discussed earlier. It must have been discussed earlier in the hearing before they got to this whole metadata, whatever stuff.
Have and what we are missing. Obviously, the evidence is important to the state's case related to the Amazon information. And given the court's direction about its intention for us to call experts today, which Mr. Howell is available, we went ahead and submitted a declaration when the court said that you were disinclined to allow testimony, and we sought leave, but we didn't get a solid answer. So you've now got an affidavit in front of you, declaration.
Typically in motions in limine, I'm not being in a position to make factual credibility findings and the like, and so the testimony on paper is more than adequate to guide the court.
Okay, I appreciate that. So I'm going to explain then what the basis is for where we're at. The other
Yeah. So Vanessa's asking, what's the gift card thing? I don't get it. They're going to have, apparently the state is going to have a forensic accountant testify, this Mike Douglas from the FBI. And then I think there's some other guy too, who's going to say, because they're trying to say that he didn't necessarily buy it, but that, that Bryan Kohberger, that Hippler said this, that Bryan Kohberger used his credit card to purchase an Amazon gift card, and that he used that gift card to buy the knife. So even though it's a shared family account, they're going to trace the money. They're following the money, the trail, and saying, no, Kohberger bought it because it was his credit card with an Amazon gift card, and then it went to him. So they're using these people to trace the purchase. But the whole thing is, let's say if he did buy this in March with the intent of doing this, why use an Amazon gift card that doesn't hide anything? It makes no sense. I've purchased Amazon gift cards and bought stuff on Amazon instead of using my credit card before, just because maybe I got extra fuel points at the grocery for buying an Amazon gift card or something like that. But that's the only reason I ever do it. So I don't know what the reasoning would be.
issue that of course the court knows is that we sought to seek suppression of the Amazon records because the warrants were extremely broad. We expected to be getting significant data or have data that we hadn't yet reviewed. The court denied that suppression issue. And so what we know that we have now is the list that I explained, but it's without metadata. And so for the purposes of what we've got going on here, there is, pursuant to Rule 106, a whole level of context that's really important to the Amazon data. And it's not just AI technology, it has to do with machine learning. And I think a lot of this is something that pardon?
Isn't that AI, machine learning?
I think that machine learning, I'm definitely not an expert on this, Judge, but I've provided you with a declaration. And if you want me to put Mr. Howell on to testify about the difference between, he's far more articulate at it than I am. It's a combination of both with what happens with Amazon. Because in terms of machine learning, one component is that when there's a household account where there's multiple users with multiple cell phones and multiple laptops going into purchases, there's machine learning and cross references there. In terms of the way that Amazon works as a company globally and artificial intelligence, they're doing all kinds of things to understand what consumers and purchasers and sellers are trying to do to actually prompt people to buy certain things. So in this instance, with regard to these purchases, we have very limited data regarding Mr. Kohberger's purchases without the metadata and the context. And that's the reason that we are seeking to exclude it. Now,
You got
Pardon?
what they got, right?
not really, because what we have is, we know that they're going to draw conclusions and that they're going to draw conclusions about intent, but the way that they've presented it to us in data is that this relates to Amazon clicks. Well, Amazon clicks makes it sound like to me and you, someone goes on and actually, with a mouse, clicks, opens a document, takes it into a cart, purchase it, and it's a much broader term than that.
And the state's testimony from their person who will testify that this is what the Amazon data shows, is that Amazon data shows that Mr. Kohberger, or at least his name, purchased the knife sheath and cleaning thing, knife sharpening, pardon me, equipment, and looked as anybody who orders on Amazon does. Where's it at in delivery? And then later on that same account, after the homicides, looked at knives again. Now, I understand the defense's position and evidence and expert to be that, well, that's a shared account and anybody could have done that on that shared account. I don't know that that's a matter of exclusion, though. Isn't that a matter of just impeachment and cross-examination and your own experts?
That if the court doesn't exclude it, then that would be the remedy and the approach that we would
Would it
take.
ever be the remedy of exclusion?
Judge, if you don't exclude it, then that would be the alternative, I
What
guess.
basis would I have to exclude it?
I started with that we did not have expert opinions at the time when we had to file a motion in limine regarding this data. And it's misleading that the way that you just portray it, that because there is a purchase in a household account, that is automatically attributable to him, and that there's somehow
Not a purchase in a
intent.
household account. It's attributable under his particular name in the account, as I understand it. Now, could somebody else in the family get to it? I don't know. I suppose your expert will tell us that. But I'm not sure how that is excluded, and I'm not sure how that's expert testimony. I understand you have an expert to say, well, all these other factors come into play and all these other things could have happened, and okay, you can put that on, but I'm not sure why that excludes the state's evidence.
Well, it would be extremely misleading, given the declaration that we've put before the court about everything that goes into the way that Amazon
You're
functions.
asking me to be the fact finder again. I mean,
I'm not asking you to be the fact finder. I'm telling you that when we don't have complete disclosures and we're playing a guessing game of what this information means, and we have deadlines where we have to file motions, then we end up in this circular situation right now, right? Because we had to file a motion about this without knowing what the opinions are and what we're lacking in data. Now I have an expert who's explaining it. We've asked you to exclude it. You're indicating you don't think it's an expert opinion. And so then the next logical step would be our expert comes in and we're allowed to confront the evidence. But you also just proffered that, that based on the information that you understand, that equates to a purchase, and I've put a declaration in front of you from an expert that says that Amazon doesn't work exactly that way. And that's the problem, that when it is represented as a click, that indicates to the average person that he sat at a desk and clicked and made a purchase, when there's a lot more to that.
and maybe I'm completely out to lunch, but as I understand it, to buy something on Amazon, you got to put it in your shopping cart and hit purchase. Am I wrong about that?
That is a step, but how it gets in your cart and what items get in your cart really has to do with the whole model and the ecosystem of the way that Amazon works, right? And so the state wants to apply argument in an argument. They will apply in
Did you guys see Ashley Jennings' face there? Did you guys see it? I need to back it up when she starts talking about the ecosystem. Did you guys see her face? Here, I got to back this up because Ashley Jennings' face, they've been pretty good at like keeping a poker face. And then the blonde in the back, this girl, okay, I shouldn't call her a girl. She looks like a girl to me. But look at this. Oh, thank you, the docket. That was super sweet of you. That's very sweet. So guys, I got to back this up, but watch Ashley Jennings' face when she starts talking about the ecosystem, and watch Jeff Nye. You got to watch Jeff Nye too. He's kind of like, oh my God. Watch this, you guys. I got to back it up like 20 seconds, and I'm going to try to not screw this up here. Oh, and I just did something wrong. Hold on. Oop. So hard to do this sometimes. Okay, we're a little bit farther than 20 seconds, but watch Jeff Nye. This is Jeff Nye. Are you guys seeing when I do my little circle things? Here's Jeff Nye. This is this younger prosecutor. She's helping the blonde back here. She's helping with the jury selection stuff. And this is Joshua Hurwitz. He's the new guy who used to be the U.S. attorney. Ashley Jennings. Watch her face when she starts talking about the ecosystem and all that stuff.
Sat at a desk and clicked and made a purchase when there's a lot more to them.
And maybe I'm completely out to lunch, but as I understand it, to buy something on Amazon, you got to put it in your shopping cart and hit purchase. Am I wrong about that?
No, that is a step, but how it gets in your cart and what items get in your cart really has to do with the whole model and the ecosystem of the way that Amazon works. Right? And so the state wants to apply in an argument, they will apply intent to purchase a K-bar to get to November 13th, 2022.
From the evidence to argue at closing arguments.
But we still have to have testimony that explains those things in between.
Welcome to put on testimony that implies that Mr. Kohberger was not the one that hit purchase, or that he purchased it for a benign event, or that here's the knife, I have it. I don't know.
And based on what you're saying, that the Mr. Cox you think is a lay witness, then I'm assuming that also extends to him not being able to testify beyond what the disclosure is as a lay witness, and no other opinions, and including Agent Douglas, who's given us no opinions whatsoever.
I don't know what they're going to say beyond that. And if they say something beyond that is an expert opinion that hasn't been disclosed.
So that, and then Alyssa Massoth, and if I'm mispronouncing her name, but none of these people will talk to us. I feel bad about that if I am. But she's like exasperated. She's like all upset because he's like not giving her what she wants. So she's saying like, there's all this stuff that goes into how something ends up in your cart. You know how it is. You log on to Amazon. They send me all emails all the time. They suggest things to me based on what I might like. But I mean, stuff ends up in my cart because I click on it and put it in my cart. I mean, I have an Amazon account, and I mean, I use it. And if something's in my cart, it's because I put it in there, or I save it for later or whatever, you know. So anyway, she's not happy.
Then the state's going to have a problem with it.
Hey, that's why we're having these arguments, Judge. They take a lot of work. It takes a lot of energy. It keeps us from 68 terabytes of evidence. Well, if everybody would just disclose, we wouldn't be having this back and forth.
The problem is you view it as a more complex issue than the state does.
Because it is.
Well, that's not their worldview, okay? And that's the factual dispute that the jury gets to decide.
So what we're trying to do is make sure that their myopic worldview is what they're held to, because there is a much bigger picture to this evidence. Okay.
Judge, this is pretty simple. Shane Cox and Mike Douglas, since he gets brought up, they're fact witnesses. They're not going to have opinions. They review records. They're going to testify to what those records show. Shane Cox's testimony is laid out in the supplemental amended disclosure. This is exactly what he's going to testify to. And what he's going to say, he's very careful in what he says that he's going to say.
Sorry, I took myself off the thing so you guys could see the big screen, and then I sat here and talked for like 40 seconds to myself and didn't put myself back on. Tayo Toys, Anjanette bought a sheath on Amazon. You are 100% correct. I did. Let me get it right here. It's right here. I did. I bought the sheath on Amazon. Here it is. And it's huge. It's like literally ginormous. So look how big it is. It's so big. I bought it on Amazon. I tell people this all the time. It's like bigger than my head. Look. Insane. So crazy. So anyway, I'm wondering, the defense had filed something in response to this a while back, and I'm going to wrap this up pretty soon. We can reconvene another time, but the defense had filed something a while back saying that there was some type of trip. I'm wondering, this is another reason why I think Bryan Kohberger might testify. This is another reason why I think Bryan Kohberger might testify. They filed something, and now I'm going to like pull it up really quick so I can share it and you guys can see this. Let me play the rest of the state, and while they're talking, I'll find it. Okay. But she's talking about their myopic worldview and how stuff ends up in your cart. I think I know where the defense, it just popped into my little head. I think I know where they're going with this. So here, let's go.
And in response, we got responsive data, and that's what we plan on presenting to the jury.
Okay, guys.
Amazon's use of AI is not a basis to exclude, and it's completely irrelevant.
I messed up again. Let me play this again. Sorry. I forgot to put it back up on the thing. Here.
And we were granted a search warrant for Bryan Kohberger's Amazon.com user activity. The search warrant was narrow in scope to items related to the homicide and evidence related to the seizing of knives. In this case, it was knives and knife accessories. It directed law enforcement to see certain items: his customer click activity pertaining to knives and accessories, his payment method used, details of items in cart, including all items added to the cart or removed from the cart or wish listed or in a shopping basket, all suggestions made to the account, all records regarding reviews by other Amazon users, advertising data, devices used to connect to the account, and all accounts linked to the account. The state requested the data between limited time periods, March 20th to March 30th, and November 1st to December 6th. Those were the relevant time periods. And in response, we got responsive data, and that's what we plan on presenting to the jury. Amazon's use of AI is not a basis to exclude, and it's completely irrelevant. AI doesn't click on things for a user. There are no legal grounds to exclude this. We ask that you deny their motion. Thank you.
Thank you. So I think there's a fundamental, just different worldview as to the relevance and impact of the Amazon data. And the defense is entitled to challenge the data in terms of, does it really show who bought it? What else did they buy? In what circumstances? I understand the state's not really going down that apart from what the data shows, which is the purchases that have been laid out in the report. If the state tries to go beyond that without having disclosed those or without a rebuttal disclosure to some of the things the defense has disclosed on that, then they're not going to be allowed to testify to it. But there's not a ground for exclusion because you have an expert that thinks that the evidence can be explained in a different way. That's just simply a fact determination for the jury based upon the conflicting evidence.
Here's part of where I think the defense might be going with this. And I'll put this up on the screen really quickly. I'm really trying to get there. I promise you. So the defense in one of their responses to this, or one of their replies to this whole thing, said, for example, the state ignores that the Amazon records reflect a household of users on the Amazon account at issue and a long list of items purchased over a period of several months for a road trip or hiking, to include a roadside repair kit, a tire inflator, a backpack, and bear spray. How about that? So are they going to say, is the defense going to say, look at that, items purchased over several months for a road trip or hiking, to include a roadside repair kit, a tire inflator, a backpack, and bear spray? Are they going to say, is the defense going to say, this was suggested, a suggested purchase, and he was going on a trip? Who knows? We never heard about how Bryan Kohberger ended up at Washington State after he graduated. Did he drive cross country? Did he do this cross country road trip? And in preparation for that, he's buying stuff over several months, including this bear spray. I don't know. Did he stop? We read on the one search warrant about a letter from Montana or something like that. Did he do this road trip and stop in Montana? I mean, that's why would you need bear spray? So are they going to say, oh, it got suggested to him, and so he bought this thing because he was going on this road trip and he went to Montana? I don't know what they're going to say, but Bryan Kohberger is the one that would have to say why he bought this thing, or somebody else in the family. And where is it now? Is the knife? Do they have the knife? Was the knife recovered, but not the sheath? We don't know. So that's where I'm wondering, is that where they're going with this? Oh, shared family account. Maybe he didn't buy it. Maybe he did. It was maybe for a road trip. But where's the knife? Where's the sheath? And where is the sharpener? Where is the sharpener? Because it was part of what he purchased. I don't remember ever seeing anything about the sharpener being recovered. So where is it? I don't know. Guys, I think I'm going to wrap it up. Stacey Ann asks, is bear spray the same as big spray? I've never heard of bear spray until tonight. Bear spray is like, I think if you go camping or something and you use it to keep bears away or something like that. So everybody, it's been fun. Thank you so much for coming and hanging out, and all your great questions and comments. We'll go through some of them. Something odd happened to me on Amazon once. Nomad Life said, received a box of earbuds from Amazon with my address on it, and I never ordered it. I contacted Amazon because not mine. Told to keep, their mistake. Interesting. Yeah, that's interesting. She fell in love says AI buys me unaliving paraphernalia all the time. Yikes. Twizzle Stick says the K-bar was purchased in like March of 22. That's correct. And then, yeah. Webby says, I can see them doing that, Anjanette Levy. Yeah, that's what I think. I kind of just popped into my head. This might be where they're going with this. So guys, thank you so much for tuning in. I just took myself off. See, I feel like it's been a long week, guys. It's been a long, busy week. I just took myself off the thing by accident. But thank you everybody for watching tonight. I'm going to wrap it up. I will let you know. I'll post early tomorrow if I'm going to be able to hop on here tomorrow for a little bit. I will do my best to do that, but I don't know if I will be able to, but I'll try. Sirius Black, BK has a fight on his hands for sure. He sure does. But again, thank you. Like and subscribe, please. And I appreciate everybody coming in, and leave your comments, and I will try to get through as many of them as I can. Like, subscribe if you're watching on replay. Thanks a lot. And I'm still working on the sign off. So everybody have a great night, and I'll see you back here again another time. Until then, have a great night.